Good morning, everybody. Fantastic to see so many of you able to join us this morning for our webinar on the rules of intestacy, and good to see lots of familiar names and faces as well. I will shortly be handing you over to our expert speaker for the next hour, which is our very own Eileen Lavelle. Eileen has been with the company for almost 20 years and is the regional head of our Southall office. So what we're going to be covering in this webinar over the next 60 minutes. So it's really looking at the overview of kind of the rules themselves, how they've come about and how they've evolved slowly. We'll also be looking at some myth busting. There'll be some time to look at the priority order, of course, and also Eileen has some excellent case studies that she'll be talking you through as well. So we'll finish with a Q&A session as well. So if you've got any tough questions for Eileen, please save them for later. But that's about it from me, and I now hand you over to Eileen.
Is that better? Can everyone hear me now?
Yeah, that's all good.
Okay, right. That's fine. Okay, great. I'm sorry you can't see me. I've got a full face of makeup, so I wouldn't frighten the horses, but I'm sorry about that. So we're going to talk about the inheritance fireworks, navigating the rules of intestacy. If Lee could flick to the next page, please.
No problem. There we go.
Great. So the historical overview of intestacy is quite interesting. Realty and personality are two separate parts of an estate. Realty is as in real estate in America, so it's your property and land, and personality is your personal property. In 1925, there were some reforms to these laws, and there were 5 different reforms. The Settled Land Act is land settled prior to death and not by a will. The Trustee Act, it was basically updating regulations of trustees' powers. The Law of Property Act, it was a transfer of land by deed. The Land Registration Act is exactly what it says on the tin. It's the procedure for registering land. And the Administration of Estates Act is the procedures for the distribution of the assets in a estate, the appointment of the personal representative, that's the executor or the administrator, depending on whether you left a will or not, and the payment of debts and taxes. If we could have the next screen. Okay, so on the 26th of July last year, there was an increase in the statutory legacy amount. It was increased from £270,000 to £322,000, and that's to a civil partner. However, it depended on whether you had children or not. So if you had no children, they received the entire estate. If you have children, then the surviving spouse or civil partner would take the statutory legacy of $322,000. The remainder of the estate would be split 50-50 between the spouse or civil partner and the children. Lee, if we can have the next bit. Okay, so the other thing that changed was the age was raised for children to inherit, and from 18 to 19. Okay, so we've got some myths here that people in the main, out in the great wide world, believe that are correct and are in law. So the first one is that a common law spouse can inherit. Lee, if we could just click to the next screen. Yeah. This is not true. They receive nothing under the rules of intestacy. The next person that would not receive anything would be a child who has been adopted out of the family. So an adopted out child would be somebody who is born to the intestate or to the family, and then has been adopted out of the family and adopted into another family. They then belong to that new family. The other person that doesn't inherit is a stepchild. On intestacy, you have to be a blood relative to receive receive a benefit, apart from a spouse or a civil partner, of course. So, the intestacy order of entitlement. So what we've got here are details about the married couples and civil partners. So what I would do, I would think about best practice on for married couples on all the next slides. If they are divorced or say they've been divorced, I would trace the decree absolute. Some people might say they were divorced or might say they weren't divorced, and it's always as well double check if they have actually got the decree absolute. The whole divorce has gone through. We can do divorce searches for you. It's quite straightforward. If they were married, would trace the death of the civil partner or the husband or wife. Was it before or after the intestate? If it's before, then we go on to intestacy law. If it was after, then the husband or wife their estate would be the beneficiary. Was the intestate survived by a member by the husband or wife civil partner? It's always as well to check for that, because they might just be living apart or separated. If they say they were married to the intestate, trace the marriage certificate to confirm it, because they may say they were married, but they weren't actually. They just assumed the surname. Again, if they were separated, check if they were divorced or just a legal separation. They quite often lie about various things in marriage. I've come across bigamous marriages. There were no marriage at all, or just a change of surname. So it's as well to think of divorced, deceased, survived, married, separated, lied. Just like Henry VIII, check those 6 things and double check that the person who says they are married to the intestate or is a civil partner are actually legally that. If somebody could you just bob back a minute, Lee, please.
Sorry about that.
No, that's all right. If the intestate and his partner are cohabiting, the partner doesn't inherit. They could make a claim on the estate if they were dependent on the intestate, and they have to prove they were dependent. There also might be a partial intestacy if assets are jointly owned. So if the surviving spouse or civil partner or cohabitee have got joint assets, half, of course, would stay with the husband, wife, or civil partner or cohabitee, and the other half would then form the estate of the intestate. Okay, Lee, thanks. So with children, it's always as well to check they are legitimate by getting the birth certificates. Because if they are illegitimate or born before the marriage, do they actually have the intestate's name on their birth certificate? This is mainly for men who pass away. So they might have had a child with their partner to whom they weren't married, but they may not be on the birth certificate. If they're not on the birth certificate, the children would not be classed as beneficiaries because they can't prove that the intestate was their father. Adopted in and out, we can check the adoption index if somebody is adopted out, or if you suspect they might be. It's also noted on a birth certificate. So if you get a birth certificate from somebody and they say, oh, I'm not adopted out, look, here's my original birth certificate, get a copy of that birth certificate, because if they've been adopted out, it will have adopted written in the margin. So the original birth certificate, of course, won't have that on, but a copy certificate would do. Stepchildren, they are not beneficiaries. They might think they are. They might think that the intestate they looked after them as their father or their mother, but they're not beneficiaries under intestacy law, but they could make a claim on the estate, again, if they were dependent upon the intestate. Okay, thanks, Lee. Parents, it's always as well to check with an intestate to see if the parent is still living or have died after the intestate. If the parent's living, or both parents are living, they would inherit. If they've died after the intestate, they would be their estate would be a beneficiary. It's always as well to check for a will and a death certificate, because it's just double checking to make sure that the parents have passed away. On one of my case studies later, this crops up as a query. So I'll talk about that a little bit later. The one thing about parents is, Amy Winehouse, for instance, she died intestate and she was divorced with no children. So her estate went to her parents. Okay. Thanks, Lee. Siblings of the whole blood. It sounds a bit Harry Potterish. Whole blood means you have two parents in common with the intestate. Half blood means you have one parent in common. Again, best practice would say check the birth certificates of the. Sorry, we're still talking about children, siblings. Sorry, my mistake. Siblings of the whole blood. So siblings, brothers and sisters of the intestate. It's well to check that the birth certificates are of whole blood, so they've got both parents in common with the intestate. As in the next bit, were any siblings born before their parents married and only have the same mother on the birth certificate? Now, that's fine if the intestate is their mother, but it's not if the intestate is their father. Again, they may have been born before the parents married. They may have been re-registered after the parents got married. That is something that we can check for. It is noted on birth index, and it will tell you roughly when, the quarter and the year when the children were re-registered. Or they may have just assumed the father's surname. Quite commonly, a child will say, "Oh, have you got my birth certificate?" And they'll give them a short birth certificate, which only has the child's details on, which looks fine. But if you get the full birth certificate, it may not have the father's details on. They may have been formally adopted in. So if mum's had a child before she gets married, she gets married and then the husband and wife together adopt the child, then it then becomes their legal child. Do double check with an adoption certificate, because I've come across one before now where the mother who'd given birth to the child had got married, and just the father had adopted the child, thinking that the mum was still the mum, and that would make both parents the adopting parents, but that wasn't the case. It was just the father then that was the legal parent of that child. I would obtain birth certificates and adoption certificates if you're in any doubt. We can always do an adoption search, and it's quite a quick thing to do. Siblings of the half-blood, again, half-blood prints. Siblings who have got one parent in common. Now, depending on whether the intestate is the brother or the brother or sister, then double check to make sure with birth certificates that they have got the parents, one parent in common. Again, people change names and all sorts of things I've come across, and it's always as well to get the birth certificates. They could be the illegitimate children of the father or the mother, of course, are siblings of the half-blood. They only have to have one parent in common. So if mum's had an illegitimate child and dad's had an illegitimate child and he's named, and then mum and dad get married and have a child who's the intestate, then both of those illegitimate children, siblings of the half-blood, would be beneficiaries if there's no full-blood relations, of course. And so they could, as I say, the parents could have previously or subsequently married with children from these relationships. So, you know, mum and dad might have split up and then dad's had some more children, mum's had some more children. So you have to look for children born before or after the intestate to make sure that you trace everybody that's entitled. Okay. So grandparents. It's very unusual for a grandparent to be a beneficiary. So if the intestate is unmarried with no children, has no brothers and sisters, and mum and dad have both passed away, always check for the grandparents. I've never found any. However, one of my colleagues, when I was talking to him the other day, did have a living grandparent, found a living grandparent who was then the sole beneficiary to the estate. I would always check for death certificates of the grandparents if you're unsure. Uncles or aunts of the whole blood. So uncles or aunts of the intestate and who've got same parents in common as mum or dad. Of course, these could be on mum's side or dad's side. So both paternal and maternal sides would be beneficiaries. Again, check to make sure that they do have the same parents in common. Again, thinking about illegitimacy, I would obtain birth certificates just to double check. If they've been born outside the marriage of the grandparents, of course, they would be half blood, so wouldn't come into the intestacy law for inheriting. I have come across this before now, where the grandparents have a couple of children. They're not on the dad's not on the birth certificate. Then they get married and have they had about 6 extra children, so there's about 8 children in common. In total, but the first 2 didn't inherit because they weren't whole blood siblings. So it's just as well to check and make sure. You usually get an idea once you start looking at the birth indexes for children of a marriage, whether or not there's some people that are maybe not beneficiaries. So it's always as well to check. And then uncles and aunts of the half-blood. As I say, they may not realise, because they've never got their full birth certificates, that they weren't the full-blood brother or sister of the intestate. It's just as well to double-check. As I say, I've come across this a number of times, especially perhaps if mum or dad had been married before, and weren't divorced at the time of the child's birth, or were still married to somebody else, had a bigamous marriage. I've come across those before now as well. So the next slide is basically a quick recap. There's 4 things that you need to think about. The first one is the rules of intestacy in England and Wales very clearly can outline who can and cannot inherit. There are different rules in Scotland. I won't go through those. I'm just concentrating on England and Wales. The second point is there are very many commonly held myths that lead to trouble. People thinking, well, I'm living with the intestate, I'm his common law wife, I get something, and unfortunately they don't. The intestate has never made a will or a statement of wishes. The third thing is there are only 8 specific classes of a beneficiary on a descending scale of importance. Basically, you can only go back to grandparents in England or Wales for beneficiaries to an intestate. As I say, husband or wife, children, grandchildren, parents, siblings, aunts and uncles, and then of course the half-blood ones as well. So those are the 8 specific classes. And an estate is very rarely bona vacantia. That means unclaimed estate, where it ends up passing to the Crown or the Duchy of Lancaster or Cornwall, depending on where you die. if somebody passes away intestate with no known relatives, their estate will get passed either to the Crown, to the Government Legal Department, used to be called the Treasury Solicitors. And if you die in Cornwall or Lancaster, it's the Duchy of Cornwall and the Duchy of Lancaster that administer your estate. The next, since we're the 5th of November, remember, a couple of facts about Guy Fawkes. He wasn't able to leave his estate by will or testament due to this Attainder Act, which was passed in 1605 after the discovery of the gunpowder plot. They basically said that they were guilty of serious crime, and it prevented them from owning property or passing it on to their families, and it all went to the Crown. Which is quite interesting, given what we know now about intestacies and so on. So they passed a specific law, so they couldn't pass any of their property on. So I've now got 3 case studies for you, which are all quite interesting. This first one done is basically making sure you check who is entitled to an intestate's estate and who isn't. If we can have the next bit. Okay, so the first thing was we had this, all these case studies, by the way, are true, but I've changed all the names and the dates to protect everyone. So David Dunn died intestate. These are sort of bits of information I've come across at the time. So I found he was the son of Harry and Marjorie, and they married in 1955, and they had 7 sons in a 10-year period. I drew out a family tree, and then I looked at tracing the brothers and sisters, as I couldn't find a marriage for David Dunn. And I couldn't find him living with anyone. I could only find one brother who, it was just his death certificate. It was well out of area, I ordered the death certificate just to see what was going on, and I managed to track down his widow. So I spoke to the widow, and she gave me some more information, and she said, I only know a little bit. She didn't really talk very much about his family. His mother, Marjorie, ran off in 1969 when the children were quite small. And all the children were taken into care because Dad had started drinking. So social services had come round and they'd taken the children into care. And she still know about this other brother called Robert Cooper, and got a different surname. So I thought, well, that's a bit strange. When she said, I know roughly where he lives. So I managed to track him down, and I spoke to him. And he said he confirmed all the information that the widow had given to me. And he said that he and 2 brothers were adopted out, but he didn't know about the other brothers. Now, 3 of the brothers, Harry, Robert and Charles, were adopted out of the family. I basically ordered all the birth certificates for all 7 sons because I wasn't sure who had been adopted out and who wasn't. The brother that I'd traced the widow for, I spoke to his daughter, and she confirmed that her father was always known as Cooper, but he'd only changed his name. And he changed his name for no particular reason that they knew of, but it was the same name than his brother Robert, which was quite interesting. They said, and then she knew that her uncle Lester was alive, so I managed to get hold of Lester, and he thought that some of the other children were adopted out and weren't. And then he said, but my brother Donald's passed away. Now, Donald passed away after the intestate. So there were then 3 possible outcomes of all of this information. I had traced the death of the father, but not of the mother. And I didn't know whether she was still alive or not. So she could be alive and would then be the beneficiary. The second thing that could have happened, the outcome would be that the Marjorie had died after the intestate, and so it would be her estate that was the beneficiary, or that she died before David, the intestate, and so in that case, then his siblings would be the beneficiaries. If we could have the next screen. Okay, so the three brothers out of the seven sons, David's our intestate, that leaves 6. 3 of the brothers were adopted out of the family, that leaves 3. Brother John, he'd only changed his name but wasn't adopted, so he would be a beneficiary if mum isn't alive or hasn't died after the deceased. Brother Lester's alive, so he would be a beneficiary. Brother Donald has died after the intestate, so his estate would be the beneficiary. So with this, I was talking about looking for parents before. I still don't know at the moment whether Marjorie, David Dunn's mother, is alive or has passed away. There's a couple of checks I can do. There's a couple of places I can write to find out, and I'm waiting for the reply on one of those. So I'm just waiting to see what comes back. This, where I've written, will tell me whether she is still alive and will forward a letter on for me, or will tell me if they can't make a trace. And the other thing they'll do is if she's died, they'll tell me when she's died and I can then get the death certificate. So that's quite interesting. The family tree, if Lee could put it up, here's the family tree, so showing all the 7 siblings. So mum and dad at the top, Harry and Marjorie. You can see that the father Harry's passed away, but mother Marjorie hasn't got a death date. David is on the left-hand side. He's our deceased. Donald died after David, so he's an estate beneficiary. Lester is alive. He's a beneficiary. John Dunn, he's the one that passed away, but left a widow and a daughter. So the daughter is the beneficiary. She takes the father's share. And Robert, Brian and Charles are all adopted out of the family and therefore aren't beneficiaries to the estate. Just one little sort of wrinkle about this. Donald died intestate, and he died with no assets. So we're going to need to take out a leading grant for Donald, depending on what David's left. And what probably Lester will administer that estate, and then Donald's estate will then go to Lester. He'll take his share of David's estate. So the next case study, Major, which has adoption issues, and these were quite significant adoption issues, and I had to speak to somebody abroad about this. So our intestate is John Major. He was married with 2 children. He then split up with his wife and got divorced, and his wife remarried. The wife and her new husband then adopted the 2 children and emigrated to Canada. At some point when the son reached adulthood, he changed his name back to Major from his adopted surname. And when the intestate was in hospital, he named his son as his next of kin. It all looked perfectly okay because he's got the same name as John Major, and he put him down as his son and given his details. He then passes away in hospital, and the hospital then contacts the son, and he registers the death as the son of John Major. Of course, he's not legally the son of John Major. He's adopted out and has no legal claim to his estate whatsoever. John Major could have made a statement of wishes or a will, but he didn't do so. And so the son is not a beneficiary, and the estate then went to cousins. I actually had to speak to the son in Canada and explain the situation. Now, I did find the adoption papers in the papers of John Major, the intestate. And so he must have known what he was signing at the time of the adoption. And I'm sure the son understood that he'd been adopted out and was not legally the blood and the birth, not legally the son of John Major, but still went ahead and tried to administer the estate. And I had to actually explain to him that his cousins would be the beneficiaries, not himself. So this is the family tree. Here's Norman and Gertrude at the top, who are the parents of John Major, his brother Frank and sisters Mary and Suzette. Frank, both parents died before John Major. And Frank, his brother, died before him. He wasn't married, had no children, so no beneficiaries there. Mary dies before John and has 3 children, so her 3 children take her share of John's estate. And Suzette also dies before John Major. She's got 1 son, and so he takes her share. So the estate would get split 2 ways, half to Mary and half to Suzette, because they passed away. Mary's half would be split between her 3 children. They would get a 1/6 of the estate. 1/6 of the estate. 1/6. And Paul would get a half of the estate because he's an only child. So it just always as well to double check, as I say, with names and so on, especially with that adoption, because it looked, for all intents and purposes, if we hadn't got involved, the adopted out son would have got would have claimed the estate, even though he wasn't entitled. My next case is Candle, which is like a Roman candle, going back to the fireworks. The intestate died as Maureen Candle in Manchester, with missing an R.
We are. I apologise for that.
Have we, Lee? Do we have the newspaper?
We do. I'll put all the bullet points up, and you can talk through that, and then after that, that's
fine. Okay, so we had an intestate, Maureen Candle, who died in Manchester. I could not find a birth or a marriage, so I looked for all births of Maureen Candle. There was nothing. I checked in England, Wales, Scotland and Ireland, and there was absolutely no birth. So then I thought, well, perhaps she's married and changed her name. So I looked for all the Maureens marrying Candles. Again, there was nothing. So I traced where she'd been living, and there was an Albert Candle living at the same address. So I thought, well, perhaps he is a brother, or perhaps he is a husband, perhaps he'd married abroad somewhere, or perhaps she's just using his name. So I decided to look at Albert. So I obtained his death certificate, which named Maureen Candle as his widow. And I then found there was only one Albert Candle marrying in the Manchester area. And he looked to be about, it would look to be about the right age. So I ordered that. And the bride was an Olga Caulfield. So I thought, well, that's strange. She must have married Olga and then perhaps gone to live with Maureen. But Olga was the right age of as Maureen, same age as Maureen. So I thought, well, that's a bit strange. So I asked my colleague, I looked again in England, Wales and Scotland with nothing for a birth there. But I did find an Olga Caulfield in Ireland. So my colleague obtained the birth certificate and it had the same date of birth as Maureen, which was quite strange. So I did, you can do a Freedom of Information request to the NHS on deceased people. And so I did this and I said that, gave the 2 surnames, and the request came back confirming that Olga and Maureen were one and the same person. They gave both surnames, both first names. So that links them both together. She's obviously changed her name and told the NHS, told a doctor and that's then been noted on the NHS's registers. Her family in Ireland had been looking for her since the 1960s. And this is the notice that I found in the newspaper archives from one of the sisters. Some of the brothers and sisters had emigrated. Some were in Ireland, and some were in England, in Manchester, and they were looking for her. And that was in 1992. They hadn't seen her probably since about 1966. When she'd been seen crossing the road, but didn't reply to when they shouted after her. And they'd never seen her since. She'd completely disappeared, but she had been still living in Manchester all that time. And for one reason or another, she decided not to keep in touch with the family. The family tree was then quite interesting. I managed to track down everybody on the family tree. So we've got our deceased on the left-hand side, Maureen. And then she had 1, 2, 3, 4, 5, 6, 7, 8 siblings. Some of these are still living. Some have passed away with issue with children. Both parents predeceased Maureen. But very interesting about names. So if you have somebody and you can't just pick up a birth for them, you do need to have a think outside the box a little bit and perhaps go down another route to get some information, perhaps from the family of the husband, or having a little think about, was the birth perhaps not registered under quite correctly by the registrar, so there's a name change there, or have they just assumed a different name? It's always as well perhaps to Google people as well. Sometimes other names come up, but sometimes people have just changed the surnames or the first names, and you don't have to legally say anywhere. You can put it in the London Gazette that you're changing your name, but you don't have to. You can just say, from this day on, I'm going to be known as, and it's very difficult when we come along trying to track down relations if people have changed their names. As I can say, the NHS FOIs are very useful. This is a chart. It's available on the Anglia Research website, www.angliaresearch.co.uk. And you can do yes or no boxes, and it'll tell you when, who inherits and who doesn't. And it works out who is going to get everything. At the bottom, you don't want it going everything to pass to the Crown. You'd rather it went to relatives. So we do the best we can to trace everybody. This video, by the way, will be available if anybody would like to see it again. And if you email marketing@angliaresearch.co.uk, they will then send you the link to the video.
And we'll also edit out the technical issues at the beginning.
Yeah. I'm really sorry about the technical issues at the beginning. I'm really sorry about that. I'm not quite sure what happened. We've got 94 people to apologise to who are watching this webinar. So again, I do apologise most fulsomely, and I'm really sorry about that. And I hope it won't ever happen again. You just never know, though, do you?
You don't.
One other thing that I would like to just mention is, once you're administering an estate, perhaps of an intestate, it might be worthwhile thinking about an insurance policy. We can get quotes for different types of insurance policy. There's a missing will insurance in case you think there might be a will, but have done a will search and can't find one. It could be held at a solicitor's who hasn't given their wills into a will bank anywhere. The other thing you can do is a missing beneficiary indemnity insurance. You can do that for a specific person that you know is a beneficiary, but you can't trace. And you can also do it, an MBI, for a comfort MBI, which is you think you've traced everybody, you're fairly sure you've got everybody, but just in case the intestate for some reason perhaps has had an illegitimate child, or adopted a child that's disappeared that nobody knows about, it might be worthwhile getting a comfort missing beneficiary insurance. And it then just covers you in case anybody does come forward, has found out that their parent or whatever has died and they're a beneficiary, and it just covers everybody. It's good practice. I would thoroughly recommend it, just in case. You just don't know who's out there. If anyone's got any questions, I'm sure Lee's going to tell me now in my ear.
Well, there have been none so far, but there is on the Microsoft Teams sort of page, there's a Q&A section. So if anybody does have any questions about anything else, Eileen's discussed.
At the top, on the button at the top, there's a Q&A, which is you can pop any questions that you have in there if you'd like to do so. If you do, I'll happily answer anything. If you've got any questions that you want to ask me specifically on, or if you just want to run something by me, please feel free. My details are on the next screen. And if you just bob those through to the next screen.
I will indeed. There you go.
Yeah, that's great. So there's all my details. Please feel free to give me a ring or send me an email if there's anything you want to ask me, even if it's just something quite straightforward. Then do feel free to do that. I see that somebody's put a question up and then somebody's answered it. Fathers that not on birth certificates, I think it was about. So if a father isn't on a birth certificate, for instance, if we've got an intestate and they have got they haven't got a father on the birth certificate. No, scrub that. So if we've got an intestate who's got a sibling, always brought up with them as their sister, but they haven't got a father on the birth certificate, then that child, that sibling, will be a half-blood sibling, not a full-blood sibling, because they don't have two parents in common on their certificates. That half-blood sibling would only be a beneficiary if there are no full-blood siblings. Apart from husband, wives, children, and so on. As I say, any questions?
There's quite a few, Eileen. So I've got one here. Brian Johnson has asked, do you think Section 7's AEA 25? I don't know what that means, but should
Section 27 AEA 25
should include administrators and not just executors, so that the chain
include administrators and not just executors.
So that the chain of representation does not break on intestacy.
So that the chain of representation doesn't break on intestacy.
Yeah.
I would need to go and have a little bit more research on that. Brian, if you want to email me about that, we can have a discussion about that, and I'll have a little look and see what we think, and then we can update the video if needs be. Very happy to discuss that with you. Okay, so Kate's asked, if we can't locate a beneficiary at all, is there a time limit? Basically, no. If we can't trace somebody, then what we would do is we would take out the missing beneficiary indemnity insurance for that person. You have to state what relationship they are and what share they're getting out of the estate, and what you've done to trace that person. Have you spoken to the family? What have you done? And then the insurance company would then give you a quote based on that information. Then the insurance would pay out if the beneficiary then came forward. But we normally, an intestacy takes between 6 and 18 months to complete. So if we are researching a family, we usually have about that time before the estate is distributed. So we've got probably 12 months to track everybody down. We do talk to lots of people in the family. We do try and talk to every beneficiary if we can, and ask them questions about the family. That's where other information comes forward about illegitimate children, adopted-in children. Was Uncle Silas actually Uncle Silas, or was he just an illegitimate child of grandma? And so it's very useful to talk to people. But as I say, we would take out the MBI once we were ready to distribute. And then if they came forward, they would then, the insurance policy would then pay out.
So the next one is, what happens when a beneficiary declines to cooperate with the representative of the estate or declines in the inheritance share?
Okay, so
we get that quite a lot.
To cooperate, if they say we don't want our share of the estate, their share sits in the client account. They can revoke their share. It would go to their children if they have any, or back up the line. But it doesn't stop an estate being administered, of course, unless they are sole beneficiary, and then you can't do anything further if they decline to do anything with the intestate's estate.
Lovely. Okay, so the next one is, if a married couple die intestate together, who is deemed to have died first? I think I know the answer to this, but I'm going to let you do it, Eileen.
Depends when they died. It depends on when they say they actually died. What do you think, Lee? What would
I would say it doesn't really matter, because if they're both dead and they're intestate, it would go to their children, or
It would go to their children if they had any. That's true. But if they had no children, it would depend on who died first. So if the husband died first, then his money would go to his wife, and then it would be his wife's family who would inherit. If the wife died first, of course, money would go to her husband, and then the husband's estate would be the beneficiary.
I mean, I imagine that's very rare, because I suppose the only way that would happen would be there's an horrific accident, and both are declared dead at the scene or wherever. But even so, there's still got to be a coroner that declares the time of death, doesn't there?
Exactly. Yes. So one would have had to have deemed to have died before the other.
Yeah. Or if they're declared.
Of course, they may well have left wills. So, you just don't know, do you?
No.
It depends on the circumstances and when they died.
I think that's a very interesting question, Deborah. Thank you for that. Right, next one. Could you explain further about a child's father who is not on their birth certificate not being a beneficiary under intestacy? I've not had to deal with this, and surely this must be very difficult to explain to the child. Would this also not affect just referring to the children in a will?
Right. If there's a will, that's fine. If they list everybody, if somebody's in a will, it doesn't matter what relation they are. If they're in a will, they get the money. I've never come across a will that just says my children. They usually specifically mention them and name them in a will. If I have had to tell people before now that their father, who they thought their father was, wasn't on the birth certificate, and so they weren't a full blood sibling to the intestate. I've actually had to tell people this, and it's really difficult. I have to tell people all the time that somebody that either is a close relation or they've never heard of have passed away, and it's something that you don't really get used to, but you can empathise with. It is something really awful to actually have to tell somebody that, especially if it is a close relation and they've been looking for them. And I do try and either visit somebody if I can. I've had to tell people that their child died. I've had to tell somebody that fairly recently, and the mother was 85. So I made sure that she had somebody else with her at the time in the house, by saying, oh, well, you might need to ask me some questions and you might forget something. So perhaps if you have somebody else there, they might ask me something, just so that this other person was there as support. It is very difficult, though, to tell people that mum and dad were married when they were born. and they had no idea. But then again, I've had to tell people that, you know, mum and dad have had children before they've had them, and they had no idea that mum's had an illegitimate child. So it's you don't know what you're going to get with this job when you start something at all.
I've had right, so it's the last couple of comments, Eileen, and then we can wrap up. So I've had a couple of comments about section 184, which deals with commentaries, and it's based. So Brian has said, if you die together, the younger is deemed to survive. So
right, okay, that's great.
So that clarified that one. I mean,
that's perfect. Thank you very much, Brian.
Thanks, Brian. And then Kate has said section 184 deals with commentary, so have a look at the section 184 Law of Property Act.
I will do that.
So yeah, this is all really interesting and great discussion.
Yeah, really good.
Yeah. So I think we've been here for an hour now, and apologies for the technical issues at the start. Eileen, thank you so much. I suppose thank you for being patient. I suppose if anyone has any queries, they can email you, can they?
Yeah, please email me. You've got my email address on there, or ring me up. Not a problem at all. Happy to talk to anybody. If you've got any strange queries, the stranger the better. It's what I'm known for. So yeah, please do email me if we can help with any questions you have. Delighted to help you.
Lovely. And here is the last slide with the kinds of services that Anglia Research can help you with.
Yeah, so we can, so this last screen, it's got all different things that we can assist practitioners with, all sorts of things that you may not think about. So we're finding missing beneficiaries in wills, free administrator search. We also do a family tree verification service, a free family tree. So if you've given a family tree and says that's everybody on it, you can bob it over to us and we'll have a look and see if there's actually anybody missing. We can do will searches for you. We can do missing beneficiary insurances and missing will insurances, as I've discussed. We can find and obtain wills for you. We can give you guidance on estate distribution, and we can do bankruptcy and asset searches as well. Anything of that nature at all that you want more information on, or you would like us to look at for you, do email me. Again, if anybody wants the video, they email marketing@angliaresearch.co.uk.
Lovely. Well, thanks so much, Eileen, and thank you to everyone for attending and for bearing with us. And we hope to see you in the future for further webinars, hopefully with less technical difficulty. But
thanks, everybody.
Thanks,
I'm going to leave now. Thanks very much for everybody coming.
Cheers.
Thank you.
Bye.
Bye-bye.